Any mention?
May please, Lordship. Lordship, I beg to mention item number 7 for the petitioner. I pray that this matter may be come up after vacation.
Yes. Any problem?
No objection, Your Lordship. The main answering respondent is MECL actually in this matter, Your Lordship.
Okay, just inform them.
Yes, Your Lordship.
Probably this is partly the cause of action.
Yes, Your Lordship. Only seniority wise in this matter left.
Just on the prayer of the petitioner, not objected to by MS Jenny London State Council. List after 2 weeks. 2 weeks.
Obliged.
Highly obliged.
Lordship, I'm back to mention item number 4 and 5.
Yes.
Lordship, still the matter is pending before the Apex Court.
Item 4 and 5.
4 and 5. So matter may come up after 4 weeks.
With this, actually, we are waiting for the disposal
Awaiting, Lordship.
of the by Apex Court. Okay, let's see, make it 4 weeks. Let's see the last order. Okay.
Please, Your Lordship.
Yeah.
You mentioned item number 13, my lord.
Yes.
I'm making a prayer for 3 weeks.
Lord, I have no objections.
The prayer made on behalf.
But also item number 14.
Yes.
This matter pertains to, my lord, POXO, where the couple is married. Well, matter is, reference is pending before the Chief Justice.
This also will come out
Praying for 3 weeks.
14 after 3
Lordship,
weeks.
I'm for respondent number 3.
Yes. Yes.
Obliged.
Wait, please, Your Lordship.
Yes.
Your Lordship, I beg to mention item number 8, Your Lordship. Lordship,
Yes.
I'm praying for 2 weeks' time, Your Lordship.
And for the private respondents, 1.5. No objection.
What is this matter about?
It's about Nokma matter, Your Lordship.
Any objection?
No objection.
Request to the petitioner, not objected to by the Lana Council respondents. Listed after 2 weeks.
2 weeks, Your Lordship. Your Lordship, similar prayer for item number 12, Your Lordship.
Yes, 12 who is appearing for the other side.
Your Lordship, for the opposite party, it's Mr. Paske, Your Lordship. We have already informed him, Your Lordship.
We have already
Yes, Your Lordship.
12. The prayer made on behalf of the petitioner, list after 2 weeks. Yes.
Highly obliged, Your Lordship.
Your Lordship, I'd like to make a mention for item 6, Your Lordship. Actually, this matter I'm from respondent, Your Lordship.
Yes.
We'll fix it after vacation, Your Lordship.
You are appearing for?
I'm from the sole respondent.
All for the petitioner.
Any objection? Same order. Yes.
Obliged, Lordship.
May I please do your lordship? I am appearing for respondent number 2 and 3 in item number 9. I would like to mention this item number 9, your lordship.
Yes.
The learned senior counsel is unable to come before your lordship today. So,
Who is this in your council?
Mr. Sandeep Jindal. Mr. Sandeep Jindal.
Sandeep Chandra.
And then another matter is there, your lordship, is item number 10.
Wait. We'll go one by one. 9, any objection?
No, my lord. In item number 9, we are for the respondent, my lord.
Item number, you are for the respondent.
Lordship, in item number
He is for?
We are also for the respondent number 2 and 3.
Who is the petitioner in item number? Any objection? 18 objection? Item 9 just on the prayer of so-and-so. No, not objected to the Lana Council of the petitioner. List after? When do you want it?
After 2 weeks, your lordship.
2 weeks.
And one more item is a connected item, is item number 10.
Yes.
And here I am appearing for respondent number 1 and 2.
Yes.
No objection.
So this also will go after 2 weeks. Just see the record, the prayer. Yes.
Much obliged, your lordship.
Item number 1.
May
Yes.
it please, Your Lordship. Lordship, the petitioner have filed a miss case for bail for
Where are
grant.
the petitioners?
They're
Today petitioner is absent, Mr. Dr. Mazur. Do not know. Let us see. We will have it. When his previous bail is expiring?
4 weeks was granted, my lord. That was on 26/8. We still have time, my lord.
26/8? No, it is almost over. 4 weeks will be 28 days, isn't it?
26.
Today is 22nd.
When it can be passed over for a time.
Okay, we'll just see. Just call it 27. We'll just see. Yes. After some time. Court also will be back after some time.
second call. Item number 1.
Yes, where
May I
did you
please-
disappear, Mr. Joshi?
Lordship, I got a little delayed.
Yes.
Lordship, we have filed a miscase for allowing the petitioner to continue with the bail order, which was passed by this honorable court, by the
What are the
court.
orders under challenge in the writ petition? In the year prayer, there is nothing specific about which order you are challenging, nothing, isn't it?
In my miscase, Lordship,
No. So far, come to the writ petition first. Your miscase can only supplement your main prayer in the writ petition. Now, what is your prayer exactly? Nothing specific. See, your client will be in problem.
Vague prayer, man.
There's nothing. What can, even if we grant this prayer, what would be, if it is, there is nothing. At least you should impugn the orders which you are challenging then. See, we do not know how many days time you have, Mr. Joshi. You withdraw this petition, file afresh. It's not possible. We cannot just make you stand corrected every time. Last time you
Lordship,
came
I
up
may
with,
be allowed to amend this prayer only. Lordship.
how, why to amend this prayer? There is nothing in the prayer. You have to bring a fresh prayer. You withdraw this file a fresh one. That remains the only thing. Yes.
Deeply.
Are you ready to do that?
Yes, Lordship. Yes. Lordship, a week time maybe.
See, the
Extend
problem
it,
is with
Lordship.
your thing.
Yes,
Can we extend the period of bail which you have granted?
Yes, Lordship. I'm just praying for a week time to be extended.
That is, okay. But the thing is that if we allow you also,
Yes, Lordship.
can we extend the prayer of bail? If you say yes, then we will do it. Legally, how much it will be permissible, we do not know.
Very difficult for me also to say.
No, so far
I'm
as
seeking
things
only
concerned, I
extension
can-
of a
I
week
can
only,
understand.
Lordship.
4 weeks was given, they come on the last.
No, they have filed it before.
They filed
but then
it
came
just-
without a miscase.
Yes, sir.
Now the grant of bail was not proper. Was it that in the last week? You were not there probably.
Yes.
You were probably out of station. Now that also the court had to point out. Now today they came up with the miscase, but then see the prayer in the main writ petition.
Lordship, I'm only praying for a week time only, Lordship.
We
to
can
be
understand.
extended.
See, you see, if something is to be given from a person's own personal consideration, that is one aspect.
Yes, Lordship.
But then when law operates in certain area, that is what the problem is. Anyway, you do not take him in custody, Dr. Majika.
On the 26/8, if they can file it by 26/9 also, my lord. 4 weeks can be taken as a 1 month, my lord. I'll not object to that.
Okay.
But
You file it before that.
Yes.
Today is okay. On prayer by Mr.
but without any.
See, you do not have to do anything except for
Yes,
amending the
sir.
prayer.
Only the
And rest of
prayer
the part you check it. You should not make it that court detects every new defect every day and then you face the consequences.
Yes, sir.
Just on prayer by Mr. Joshi, Learned Counsel, appearing for the petitioner. This writ petition stands. dismissed on withdrawal with liberty to file afresh. Miss case also in view of the order passed so and so stands.
Withdrawn.
Item number 2.
Lordship, an affidavit has been filed after obtaining the report from the post office.
So whether Resolution number 4 has been served?
Affidavit, yes. Page number 9 of the affidavit.
Anyone appearing for Resolution number 4?
No, Lordship.
Who is Resolution number 4 here?
Is a private respondent.
Private individual? Is
Yes,
a
Lordship.
complainant or?
Complainant.
Complainant instantly to the effect that who had filed a missing report.
This is not a sexual offence.
No, sir, not sexual.
This is
302.
okay. This is a complainant.
Complainant.
Served. No one is appearing. Okay. Just say. Mr. Podde, Learned Counsel, appearing for the petitioner submits that an affidavit showing the factum of delivery of sectum of service of notice upon the Resolution number 4 has been filed. By the petitioner after obtaining delivery information from the postal authority. However, none appears for the said respondent when the matter is called out today. What shall we do now, Mr. Thaba?
Time may be given, Your Lordship, for the respondent number 4 to appear.
Yes, Lordship. Matter may be listed after 2 weeks, and if not appearing, then
Respect for the
proceed
parties.
ex parte.
Give a paragraph, respect for the parties. List this matter after 2 weeks to enable appearance of the respondent number 4.
Hearing item number 3.
Yes.
Maybe please, Your
How are you,
Lordship.
Mr. Mahanta? You are all right
Better,
now?
much better now. And your oblige, Your Lordship, what happened? The matter has been settled in the mediation, but only one problem is there, that it has been written that we also agreed from the cantonment that until the building bylaws approved by the government, we won't demolish. That part has to be taken care of.
No, but then
Otherwise
if it is recorded in the before the mediation process, so we cannot do anything. You have to get it corrected there. Probably you can do it. Why don't you file a joint application there and get that order?
Just I have sent that, I talked to them, that they say,
Because if it is a kind of clerical error, then it can be corrected without changing the.
no, but stays there from this honorable court. So,
No, that is all right. It's about the settlement.
no, only that part that we agreed not to demolish. That part is a little bit
It was sent to mediation, isn't it?
sent
So
to mediation.
whatever settlement you have arrived at, that is reflected in the.
In the order itself.
Okay. In the mediation.
Mediation.
Okay. So far as we are concerned, it is for us to either to accept or not to accept, depending on the condition.
I think it can be accepted also.
Okay. So if you say it is so, yes.
Your Lordship, these terms and conditions had already been accepted by both parties in mediation.
Okay. So we can close the matter then, on the basis of the terms and conditions. Yes. Hart, MS, P. Nongri. Nongri.
Your Lordship, I'm R. Fenkin for P. Nongbre.
You are you an advocate on record in this case?
Yes.
Okay. I'm Mr. So-and-so, Learned Counsel for the petitioner, and also Mr. S.P. Mahanta, Learned Senior Counsel, assisted by MS.
LDN, thank you.
Okay, okay. Learned Counsel, so-and-so.
Lordship, I appear on behalf of respondent number 2, 3, 5,
And
and 9.
also Miss so-and-so. Yes, yes. This court is very poor in remembering name, Mr. Mohanto. Every day you ask
Gradually, your
it.
lordship will recognize.
And you have so many members. So you are assisted by one council today, tomorrow by another council. And then, anyway, just give a next paragraph. It is submitted by the Learned Council. It is submitted on behalf of the parties that the matter has been settled by the parties.
The mediation agreement may be reflected in the order, I feel. This is 17 September 2025.
Before the adjustment, before the before the mediation committee.
Yes.
Where is that?
This is there in the record. 17 September 2025, Your Lordship. Signed by all the parties.
Okay.
Mediation agreement.
Yes. Okay. What is it? This is submitted by the Learned Council. Before the High Court Mediation Committee. Before the High Court Mediation Committee, and a mediation agreement dated 17th September 2025 was executed between the parties, laying down the terms and condition of the settlement. Stop. It is therefore submitted. Stop. It is therefore submitted that writ petition has become infructuous, and the same can be closed on the basis of the mediation agreement. Give a stop. Paragraph. In view of the submission made by the parties, this writ petition stands closed as infructuous on the basis of the mediation agreement dated 17th September 2025.
Yes, both the cases. There are two cases.
The date is same. Date
Yes,
of the
same.
mediation
That is
committee
same.
report is same.
Both the cases.
And parties are also same.
Yes, yes.
So all the councils name.
Yes.
Because if anything goes wrong, the council will have to take the responsibility. So it has.
It's much.
11.
Both the same.
My lord, this is that matter where I have asked for constitution of an SIT to investigate into the case leading to the death of
Yes,
the
where is
petitioner's son.
Where is Mr. Harmi? Whether any status report has been filed?
I have not received anything.
Yes, Mr. Harmi.
Lordship, in this matter, the IO has filed the FR, Lordship, final report.
Okay. So, the FR, before it is accepted, a notice will come to you, isn't it?
Pardon, Lordship.
My lord, the petition still survives, my lord.
We are not saying that it doesn't survive. Let us see what happens there.
Yes, my lord. I do not know whether the FR is filed or not. So this is only
I'll receive the copy today, Lordship.
So, what is to be done now?
So let be taken up after 1 week, Lordship. I'll get the copy today.
The problem is that, you see, pendency of matter before two authorities becomes a problem. Now, if we pass one order here and something else is passed there, say supposing this court allows your petition, but then their FR is accepted, that will create contradiction. And if you reject your case and their FR is not accepted, the magistrate says no further investigation should be conducted, that also will create another.
my lord, in my humble submission, my lord, this proceeding is independent of whatever is filed here, my lord.
But
Whatever
then
has been filed.
what would happen to the order passed by that court?
My lord, in any case, I will receive a notice, my lord. I have a right to show cause on that FR.
So we can get your this thing remedy there. Remedy can be redressed there. Just see.
My lord, I'll place the law. My lord, we'll say that even after charge sheet is filed, my lord, this writ petition in this nature is maintainable. My lord, why I am asking for the investigation to be transferred to some other independent agency other than the William Nagar police station, Your Honor, is because of the fact that there has been no investigation.
But then the thing is that, Mr. Karmi, you are supposed to file before this court, whatever the outcome of the investigation. That report has to be given. If it is FR also, you have to give us.
Yes, I'll file.
Let us see what kind of investigation is.
Yes. Today I'll get it, Lordship.
And the investigation, my lord, has taken place in piecemeal, my lord. Every time I have come to the court, they have done some one thing or the other.
Mr. Gautam,
my lord.
You see, any order by this court at this stage directing some other agency to investigate the matter.
My lord, that is, of course, if I am able to satisfy, my lord.
One thing is that even if you are successful to
my lord,
what purpose it will serve? If you take it
my lord,
from
at least
the
it will
date of incident. See, initially you also kept mum. Your suspicion arose only after you received some WhatsApp message. Isn't
my lord.
it? And thereafter also you filed. Just we are giving our exchange our views.
My lord.
Don't think that the court has taken a view that order will be possible.
Absolutely not, my lord.
We are just trying to communicate to you in the background of the circumstances. Even if you are successful in obtaining some order, what purpose it will serve? The involvement of any superior investigating authority or any different authority also, you see, like may not throw more light here. Just anyway, let us just see what basis FR has been, whether he says there is no sufficient evidence or not. Let us see what the IO has done. And then probably, if you have a right to be heard before this FR is accepted, I think pursue your cause there. This court, without having sufficient materials, becomes very difficult.
My lord, the materials are there before this court. My lord.
To what
My
extent
lord,
we can
let them file the FR, my lord. Then
we are not closing it today.
my lord.
But then even if it happens, you see, like to what extent we can examine the correctness of investigation.
Now, my lord will kindly, if I may submit, my lord kindly appreciate this, that initially, my lord, the death happened in suspicious circumstances, my lord. Initially, it was attempted to be closed out as a case of unnatural death, without even causing any kind of investigation into the matter. The IO never went to the place of occurrence. The the statement of the people who fished out the body, they were never taken.
This court remembers it.
And
that was done on the basis of the information or the investigation which police got at the very first instance. Even you see the suspicious role by the companion of the deceased at that point of time, which you are pointing out at this stage. Their statement appeared to be something different at that point of time when IO investigated the matter at the very first instance. There was no indication of any foul play. That is what the problem is.
Now, my lord, nevertheless, a death had happened, my lord. A valuable life was lost. So the IO was required to investigate on all aspects. On all aspects. Nothing was done. Never visited the place. Now, subsequently, my lord, before my lords, an affidavit has come. My lord, we have said that post-mortem did not take place properly. The doctor conducting the post-mortem has filed an affidavit saying that I did not conduct the post-mortem as per procedure because I was approached by some people. Now, my lord, this clearly indicates that in this case there is something more than meets the eye. My lord, there is something very fishy here that needs thorough investigation. My lord, this is a case of this is a very serious case. My lord, a very serious case in the sense that a valuable life is lost in mysterious circumstances. We are repeatedly, time and again, we are coming before the court and saying that investigation is not done. Earlier we came before the court, my lord passed an order, then they started investigation. Thereafter, then again they stopped. Then we had to approach the magisterial court also. Thereafter, there also they did not do anything. Only when we filed the writ petition before this court, my lord, they went to the they took a step of exhuming the body, and then thereafter now, when this petition is pending before my lords, a submission is being made that the FR is filed. Let us have a copy of the FR, my lord.
Did not raise any dispute, Lordship. In fact, before
I can understand that.
they have filed the application for exemption of.
No, we
My lord,
have to
that exemption
And
was
now-
not filed by us. It is not filed. We have categorically
After
mentioned.
the FIR also, it was filed after 3 months.
What needed on your part is, Mr. Kharmi, that when the petitioner received those communication through WhatsApp, there at least you should have been very sincere. At least you should have caught those people. You should have asked them what made them to communicate this kind of communication to the petitioner. Probably that way there could have been more light into the matter. Anyway, we are not there to suggest anything because we are also not, we have no expertise so far as the investigation is concerned.
Yes, my lord.
Neither petitioner can prescribe in which manner.
No,
it
my
should
lord.
be
I cannot.
investigated.
I can only say that the investigation is not proceeding in the desired
Let us
manner.
see what happens in the thing.
And the investigation is not instilling public confidence, my lord.
Yes, just Mr. Kharmi learned it. Additional PP appearing with the state submits that he has received instruction with the latest status of the investigation. And prays for grant of some more time for bringing it on record by way of an affidavit. By way of an additional affidavit. Pray, how long will it take?
Oh, 1 week. 1 week.
And 1 week to is useless anyway, it's too less. Let him bring it on record as prayed for.
After vacation.
Later, Lord. List after 2 weeks. Just 2 weeks.
Oblige.
See, Mr. Gautam, just see on what can we do legally. You see, it is not that court is moved by sympathy.
No,
We should be practical at the same time.
Absolutely not.
Same time. Please give us something, guide that way. It should not be something on that you are emotional and you want something to be done. And we follow it without realizing practically what's the purpose it will serve. It should not be something like that also.
Transfer of investigation also it cannot be done.
Issuing futile direction serves no purpose.
Yes.
Probably we may have the power to direct some authority to investigate. But then even if their investigation also serves no purpose.
My lord, there are cases, my lord, where investigation has been transferred even after the charge sheet has been filed, my lord. I will place those cases,
We
my
are
lord.
talking about the legality of a thing. This court has no difficulty
My lord.
in understanding that the court has the power to issue such direction. But then it depends upon the situation. That is what.
Transfer of investigation only if there is biasness or insufficiency
Let us
in the
see.
investigation.
But then there should not be any negligent approach. You see, it is not that biasness and all. Negligence
Biasness.
also matters.
Negligence.
Competency also matters.
Yes.
Oblige.
15.
Bring on records those relevant part of your FR and all. Just do not file only one affidavit. Give supporting document.
Oblige.
Yes, Mr. Pandey.
May it please, Lordship.
Yes.
This petition is filed under Section 528 of Bharatiya Nagarik Suraksha Samhita, Lordship, for quashing and setting aside FIR dated 15/10/2029 and subsequent case pending in the Honorable Court of Judicial Magistrate, First Class, Lordship. The brief fact of the case, Lordship, is that there was an accident, Lordship, involving a motorbike in a car in Laimukra area of the city, Lordship, in 2019. An FIR was filed, Lordship. FIR is placed at page number 9 of the writ petition, Lordship. Type copy would be in the subsequent page, Lordship. May I read, Lordship?
Page 11.
Page 11, Lordship.
Yes.
To the officer in charge, Limecrop Traffic Branch, Iskha Hill, Shillong, first information report. With reference to the subject cited above, I have the honor to inform you that on the 11th of October 2019, around 12 am, my son, Sri so-and-so, made an accident while riding his motorcycle bearing number so-and-so with a Maruti car number so-and-so in Limekra, Arbuthnut Road. The delay in filing the FIR was due to hospitalization of my son. Kindly take necessary action. yours faithfully, so and so, who is the mother of petitioner number 5, Lordship.
Who are you? Who are you? What is your status? You are?
Lordship, I am the petitioner, Lordship. I am the owner of the Maruti car, Lordship, which was involved in the.
But then your car thing is not mentioned there here.
Lordship, not mentioned.
So how your role was revealed?
Lordship, because.
Okay, Maruti car is there.
Yes, Lordship.
But that has been mentioned.
Number also has been given, Lordship.
Okay.
Now, Lordship, the FIR is clearly mentioned there was hospitalization, Lordship.
Yes.
And what happened? Respondent number 5, Lordship, was hospitalized, Lordship. Who was respondent number 5 was the one who was riding the motorcycle, Lordship. He was hospitalized, and subsequent to hospitalization, there was an agreement reached between the parties, Lordship. As per the agreement, hospitalization bill as well as the repair cost accrued in the repair of
there is
the
some
bike.
order similar kind of
Lordship,
matter.
Lordship, I have annexed the Lordship also. That. So the hospital bill as well as the repair cost of the bike was borne by me, Lordship. And that agreement is placed at Lordship, would kindly see in page number 23, Lordship.
Yes.
Lordship, is a settlement deed, Lordship. This deed of settlement is made on 15th day of July 2025 at Shillong between so and so party, Lordship. Whereas the first party, that is Srimati so and so, is the mother of Sri Rupert Raymond Theodore Wankar, who is respondent number 5, Lordship, who had filed an FIR dated 15/10/2019 before Line Worker Traffic Police, alleging that on 11th October 2019 at around 12 a.m., her said son made an accident while riding his motorcycle with a Maruti car number so and so at Lightmukra, Arbuthnut Road. And she also stated that delay in filing the FIR was due to the hospitalization of her son. And based on the said FIR, the investigation officer registered the case Wide Lightmukra PS case number so and so under section 279, 427, 337, 338 of IPC. And the investigation officer, after completion of the investigation, had submitted charge sheet, white charge sheet number 12 for 2020, dated 07/07/2020, against the accused person under section 279/427, 337 and 338 IPC. And upon submission of the charge sheet, a regular case being GR case number 52/S of 2020 was registered against the second party, which is pending trial before the Court of Learned Judicial Magistrate First Class at Shillong, Lordship. And whereas, Lordship, this is important, Lordship, whereas the first party had voluntarily on 31st/10/2019 paid the hospital bill as well as repairing cost of the bike, the model number of the bike is mentioned, Lordship, and the number also of the first party, and the acknowledgement receipt of amount of the said effect have been duly signed by the first party, copy enclosed. The copy is enclosed in the last page, that is page number 26, Lordship. Whereas the party have mutually resolved to settle the matter amicably between themselves, and as such, the parties thereto agrees to approach the appropriate court for quashing the FIR as well as the consequent proceeding. Now this deed witnessed as follows, that the first party do not wish to pursue the FIR dated 15/10/2019 lodged with the Lightmukra Traffic Police and the corresponding case, GR case number 52S of 2020, which was registered against the second party, and now pending trial before the Court of the Learned Judicial Magistrate First Class at Shillong. That in view of the above settlement, the parties here to have agreed to jointly or individually to prefer an application before the competent court, bringing on record the settlement reached between the parties, and shall approach the court for quashing and closure of FIR dated 15/10/2019 and the proceeding of GRK so and so under section so and so of IPC, in order to bring on end all issues and cases between them. That the parties hereto shall cooperate with each other in all manners necessary and whenever required for the purpose of closure of the case. That the parties hereto have entered into this settlement voluntarily without being influenced by threat and coercion. That the parties thereto shall not cause anything which may adversely affect the interests of the other. In witness thereof, the parties hereto set their hands on the date, month in here mentioned above. The parties are Srimati Juliana Mary Wankar and Rupert Raymond Theodore Wankar on the first party, and Sri Marching Wallang second party, the petitioner, Lordship. And there are witnesses also, Lordship. Now, Lordship, this Honourable Court has, in similar circumstances, Lordship, passed an order, Lordship, dated 18th February 2024, Lordship. Would kindly.
So your case will be covered by this.
Lordship, absolutely, Lordship, squarely covered. Lordship.
Other side, who is appearing?
Appearing for respondent 4 and 5.
So you have no, you are the private respondent.
Yes, Your Lordship.
And you agree that there is a settlement.
Yes, Your Lordship.
So you have no objection to the prayer made.
No, Your Lordship.
And Mr. Khain? Any objection? No objection. Okay, just your name, then you do so. There will be, we'll pass more or less. You have gone through that judgment of the thing, this court. This probably will be covered by this.
Lordship, there is, in fact, there is another judgment passed by Honorable Coordinate Bench of this Honorable Court, and Your Lordship has mentioned this order in the order which.
This here.
Lordship.
Okay, if it's anyway, you can
Place
pass
these
on.
also, Lordship.
So we'll pass more or less similar order.
Lordship. Obliged, Lordship.
Yeah. Just see this order by this court, and then the pattern will be same more or less. Instead of wasting time, if there is no dispute within the parties, so we'll just go. Yes. You can do it by yourself, or shall I send it to? Okay, just send it to my thing. No, aren't you free? Just come and just.